Mr. Chief Justice, and may it please the Court, if the individual mandate is unconstitutional, then the rest of the Act cannot stand.
My approach would say if you take the heart out of the statute's gone. That enables Congress to do what it wants in the usual fashion, and it doesn't inject us into the process of saying this is good, this is bad, this is good, this is bad. Seems to me it reduces our options the most and increases Congress's the most.
So the exchanges function perfectly well in Utah, where there is no mandates. They function differently, but they function. And the question is always, does Congress want half a loaf? Is half a loaf better than no loaf? And on something like the exchanges, it seems to me a perfect example where half a loaf is better than no loaf. The exchanges will do something. They won't do everything that Congress envisioned.
If we strike down one provision, we're not taking that power away from Congress. Congress could look at it without the mandatory coverage provision and say, this model doesn't work, let's start from the beginning. Or it could choose to fix what it has. We're not declaring one portion doesn't force Congress into any path. Bottom line is, why don't we let Congress fix it?
You are echoing the earlier premise that it increases the judicial power if the judiciary strikes down other provisions of the Act. I suggested to you it might be quite the opposite. We would be exercising the judicial power if one act was, one provision was stricken and the other remained, to impose a risk on insurance companies that Congress had never intended. By reason of this Court, we would have a new regime that the Congress did not provide for, did not consider. That, it seems to me, can be argued at least to be a more extreme exercise of judicial power than striking the whole.
I mean, a lot of this is reauthorization of appropriations that have been reauthorized for the previous 5 or 10 years. And it was just more convenient for Congress to throw it in the middle of the 2,700 pages than to do it separately. I mean, can you really suggest, they cite the Black Lung Benefits Act, and those have nothing to do with any of the things we're talking about.
There are so many things in this Act that are unquestionably okay. I think you would concede that reauthorizing, the Indian Health Care Improvement Act, changes to the Black Lung Benefits, why make Congress redo those? I mean, it's a question of whether we say everything you did is no good, now start from scratch. Or to say, yeah, there are many things in it that have nothing to do, frankly, with the affordable health care. And there are some that we think it's better to let Congress to decide whether it wants them in or out. So why shouldn't we say it's a choice between a wrecking operation, which is what you are requesting, or a salvage job, and the more conservative approach would be salvage rather than throwing out everything.
The Breastfeeding Act, the getting doctors to serve underserved areas, the biosimilar thing in drug regulation, the Class Act, those have nothing to do with the stuff that we've been talking about yesterday and the day before. Okay? So if you tell me at that level, I'd say sure. They have nothing to do with it. They could stand on their own. The Indian thing about helping the underserved Native Americans, all that stuff has nothing to do with it. Black lung disease, nothing to do with it. Okay? So that's, you know what you have there? A total off-the-cuff impression.